Well, after months of back and forth, the government finally tabled the Digital Personal Data Protection Bill in Lok Sabha. The IT Minister has clarified that the bill will not be classified as a money bill. This after the opposition parties raised concerns. Now, CNBC-TV18 has exclusively accessed the final version of the bill, which is significantly different to the last draft made public in November of 2022. Here's a look at the changes. Number one, this is one of the biggest changes. In the earlier version, the government was supposed to notify countries where data can be sent for processing a positive list. The government has done away with that, has done a complete 180 and has decided to grant relief to the industry. It will now be notifying countries where personal data cannot be sent for processing a negative list. Number two, in reduced compliance for entities collecting data, the final version has done away with the need to seek consent for transfer of personal data to a third entity for processing. Number three, there's some relief for startups. The earlier draft allowed the government to exempt certain entities from complying with the bill. In the final version, the bill explicitly mentions that startups could also be exempt. Number four, the government had received considerable feedback on a clause in the earlier draft which required for entities to seek consent from parents while processing personal data of children. It has now been tweaked a bit. If the government is satisfied that the personal data of children is being handled securely, it may prescribe an age beyond which the entity collecting data may no longer require parental consent. Number five, there have also been a couple of additions. The government has given itself the power to block certain entities. The government has also given itself the power to seek any data from entities for purposes of this act. Number six, in another tweak to the earlier draft, the final version of the bill gives the central government immunity from lawsuits. This is in addition to the immunity enjoyed by the Data Protection Board, its chairperson and its members. Number seven, interestingly, the maximum penalty, which was earlier capped at 500 crore rupees, has now been done away with. There is no upper limit now as far as the penalty is concerned. And finally, number eight, decisions of the Data Protection Board can now be challenged before the TDSAT. As per the earlier draft, it could be appealed only before high courts. Now, on that note, let's in fact listen in to the Minister, Ashmit Kumar, tabling the bill in the Lok Sabha and clarifying that it is not being classified as a money bill.
प्रश्न उठाया कि क्या ये फाइनेंस बिल है, क्या ये मनी बिल है या जनरल बिल है। मैं एकदम स्पष्ट तरीके से माननीय मनीष तिवारी जी ने कहा था अभी, मैं स्पष्ट तरीके से सदन के सामने आपके समक्ष रखना चाहूंगा कि ये एक जनरल बिल है, ये मनी बिल नहीं है। इसके ऊपर पूरा डिटेल में डिस्कशन होगा।
Well, it's a landmark moment this, and joining us now to discuss this further is with us Mr. R. Chandrashekhar, former Telecom Secretary, Rama Vedashree, former CEO of the Data Security Council, and Shahana Chatterji, partner at Sharda Ramachan Mangaldas. Also with us is Mr. Sachin Taparia, Chairman and CEO at the local circle. Gentlemen, ladies, thank you so much for joining us on this show today. Mr. Chandrashekhar, let me begin by with talking to you. It's been 6 years since the Supreme Court declared privacy to be a fundamental right. We finally have something that gives us some semblance of a regulatory framework. The statement of objective is that there was a framework required for protecting the rights and also allowing for obligations of entities collecting data and also, in fact, providing a regulatory framework. Have we achieved that? Your quick take on that.
Yeah, my quick take, Ashmit, would be that, yes, this has been pretty good. This is a pretty good compromise after a lot of back and forth. The 2019 bill was criticized as being too complicated. The 2022 version, it was felt was so simple that it left out a lot of important details. And I think this has kind of struck a much better balance than any of the previous bills. So in short, I think it has taken the feedback, made the necessary changes, and pretty much, I think, sort of squared the circle in terms of the issues that were raised earlier. There are one or two minor points, but maybe I will come to that later. But overall, I think it has been a good balance after the earlier efforts. Ashmit.
Right, so a fine balancing act. This is one bill that affects all entities across the board on the digital spectrum. So this is clearly something that is generating a lot of excitement, a lot of questions being asked of us. We'll try to answer some of them. So let's dive straight away into the details. Ms. Vedashree, let me come to you. You were a part of the original committee under Justice B.N. Sri Krishna that was formed to look at this framework. Now we have one. Your quick take on some of the changes that we've seen over the years. The government now, for one of the biggest changes is they are no longer prescribing a positive list of countries where data can be sent for processing. Now it's a negative list that barring certain countries, all other countries will be kosher. Your quick take on that.
Yeah. At least first, I'm very happy that the bill has been tabled. We have to see now what are the next steps towards enacting it. And it enables cross-border data flows with notifying any countries to which you cannot do. I'm also very happy with the point that any changes to this clause of notifying to which countries data transfers will not be allowed or cross-border data flows will not be allowed will be tabled in Parliament. There's a clause to that effect where 16 and 42 clauses, sections, if there are any changes or any notifications to that will be tabled in Parliament. But I also hope while, this has been enabled, I think the existing regulations and laws which may be restricting cross-border data flows may continue. And I do hope our government, which is Ministry of Electronics and IT and Industry, will engage with other regulators so that this gets actually harmonized in the interest of industry.
Sure. Ms. Vedashree, let me in fact come back to you with the supplementary question. One of the issues that had been raised was with respect to compliance and the burden that it places on the innovation ecosystem. So that's startups that we're talking about. Now we have a bill that explicitly does mention startups in saying that the government will reserve the power, does have the power to exempt certain entities, including startups, from compliance. How important an aspect is that?
No, I am not really a great supporter of so many exemptions, including startups. I would say we need programs to be able to support startups to scale up their capacity building in terms of privacy by design and implementing privacy. Whereas a broad exemption to startups, because startups do play in the area of fintechs, in the care of digital healthcare. So I'm not a great supporter of so many exemptions, first to agencies and instrumentalities of government, and the potential power with government to qualify more data fiduciaries for exemptions. So we need to look at how that will plan. If it's just an enabling provision, I'm okay. But if this will lead to blanket exemptions to startups, I think we should be worried in the cause of privacy as a fundamental right.
I think that's a very important point that you raised on exemptions. I can see Mr. Taparia wanting to join the conversation. Mr. Taparia, I'll just come to you in a bit. Ms. Chatterjee, let me just take your perspective first on the issue of penalties. This is one key component here. The November 2022 draft provided for a cap of 500. For a single instance, for a single offence, the penalty could not exceed 500. That cap has been done away with. But in the same breath, we also don't have any criminal consequences for the action. So just your take on this one, removal of the cap, and number two, the fact that there are no criminal consequences.
Sure. So I think the reference that you made to the earlier iteration of the bill, our personal take on that was that that was actually more of a drafting issue than anything else. I don't think that the intention of the drafters at that point was to create a cap on the penalty that could ultimately be imposed. But I think that has been addressed in this version of the bill that was tabled in Lok Sabha today. And what it says is that it's given a whole, schedule of penalties that can be imposed depending on what is the non-compliance. And in fact, the board has to take into consideration various factors when it is imposing this penalty. And what this bill further says is that these penalties, the highest of which is about 250 crores right now, they can only double the existing penalties, right? So that 500 crore number still is relevant. But I think they have done away with some of the, confusion that was arising from the drafting in the earlier iteration. Now, as far as focusing on a penalty framework, moving away from criminal prosecution, I think that's a fantastic move. It's very much aligned with the Jan Vishwas bill also. In fact, that has been tabled and being discussed in this current session. I think it's very consistent with the way in which data privacy frameworks globally operate as well. So for me personally, that is a win.
Sure. Mr. Chandrashekhar, one of the issues that had been red flagged a number of times by the industry was the issue of quote-unquote age gating. The concern of the industry was that every time we process the data of a child, if we were to seek a parental consent, that would again raise logistical concerns. The government has now sought to answer that by saying that, look, we'll come out with a framework where if the treatment of this personal data of children is verifiably secure, then we could prescribe an age limit beyond which you may perhaps not require parental consent. Does this answer the concerns of the industry, Mr. Chandrashekhar?
I think to a significant extent, this does answer the concern. Of course, norms will evolve with time over what kind of situations, what kind of data, what kind of companies are given the green flag for processing such data without the consent of the parents. Because there are, as we all know, a number of uses of digital information which are required for educational purposes and for a lot of other purposes which minors would legitimately need. So I think that is something which will keep evolving. I don't think this is the final form. There will be more detail in the rule, and in practice, what happens. For example, China has recently come up with a rule restricting usage of the internet on the mobile phone to 2 hours for minors. So I think worldwide, this is a question on how do you restrict usage by minors to legitimate purposes and how do you bring in parental consent. So I think this is the first step towards cautiously relaxing the earlier rigid 18-year rule, which was perhaps too onerous. And I think this is a step in the right direction, but I don't believe that this is the final configuration that we are seeing.
So this may not be the final form. But speaking of form, well, an important question that in fact was raised today by a local circle survey that in fact came up was it pointed out that even as the Parliament is taking up the data protection bill, survey findings reveal that a lot of people, and this is the number to be specific, is 7 out of 10 respondents to this survey pointed out that they believe that their data has already been leaked or is in the public domain. Mr. Taparia, let's come in on that. That even while we do have a data protection framework coming in, there are concerns that have been expressed, at least by way of the respondents in your survey.
So, Ashmit, let's start with the positive first. I think we have come a long way that this, framework, this bill is here today. It's being discussed in the Parliament. I remember 2014-15 when we did our first survey on the subject, when the original committee was being formed as to what is personal information to Indians. So I think we have come a long way. I think the key issue, a couple of issues here, really. The first one being that, a lot of data is already out there, like you rightly mentioned. Recently in Hyderabad, they found the Cyberabad police over there found somebody with 66 crore records. We have a population of 120 crores, right? And out of that, a lot of, the population is minor. So pretty much everybody's data is already out there in some way, shape, or form, right? So our survey, what it has found is 7 out of 10 Indians believe that their data is already out. And this is their mobile numbers. About 50% of them believe their PAN card and Aadhaar card are already in the public domain, right? So that's a big cause of concern. The second thing that we asked Ashmit in this survey was, how do you think your data got compromised? And 80% of, whose data they believe has gotten compromised have basically said that their data got compromised through a government office, right? Examples of, local RTO, examples of property registration offices, and a variety of other offices, have been cited by people basically, which they hold responsible for their data getting compromised. Then you have telecom companies, the last mile of telecom companies, the last mile of banking, those are the key areas where people believe that their data has gotten compromised. So giving an exemption to the government I think, is probably the biggest question mark from a citizen perspective. Because what that does is basically, the practices of selling, sharing data by government offices at all levels, are going to continue in some way, shape, or form. So I think it's highly critical that there is some provision that penalizes, that particular government entity in form of fines and in some other form, and the staff that is out there, basically, that is out there, sharing and compromising people's information. So that's the first point I want to make. The second point that I want to cover also is, if you think about how, this bill is laid out and some of the provisions, and I haven't gone through the latest version. So, the concern is if everybody's data is already out there, right? And if somebody files a complaint with the authorities, the new regulator which is going to be formed, right? The argument from the private companies is going to be that, this person's Aadhaar, mobile, PAN card, credit card, everything is already out. So what is, it's in the public domain already. So what have we compromised, right? So I think that's something that we have got to really take a hard look at is how do you handle, all that is already out there? And then how do you minimize these exemptions so that way going forward, we really are able to address this issue of people's data getting compromised.
Right, Mr. Taparia, you've raised an important point here, one of exemptions. There is no blanket exemption, but the government has retained the power to draft rules to exempt certain entities, both private and as well as government. That's an important point. We'll come back to that. We leave it hanging for just a bit. We're heading into a very short break, but on the other side, we try to get more answers as far as the final version of the draft of the data protection bill is concerned. Don't go anywhere. We'll be back in just a bit. Welcome back. We're in conversation with Mr. R. Chandrashekhar, former Telecom Secretary, Rama Vedashree, former CEO of Data Security Council, and Shahana Chatterji, partner at Shardul Amarchand Mangal Das. Also on the show with us is Mr. Sachin Taparia, Chairman and CEO at local circles. Mr. Chandrashekhar, let me come to you with the point that Mr. Taparia had raised, the exemption that is available to the government. It's not directly there in the form of a blanket exemption, but the government does have the power to notify government entities which can be exempt. And I'll just club it with a concern that had been raised by Justice P.N. Sri Krishna, that at a point where you have the Data Protection Board, where all the chairmen, the members are nominated, appointed by the government, will it really be independent or will it be a captive entity of the government? Mr. Chandrashekhar.
Yeah, I think there are a whole lot of issues involved here, Ashmit. First of all, let me come to the question of the securing the data and the leakage of data. I think earlier, with the earlier draft, the concern was that the consent provision for transfer of data to a third party was too onerous, and it would be difficult for data fiduciaries to comply. And therefore, it has been modified to allow such transfer when the data principal gives his or her consent. On the other hand, the data principal does not know in the present formulation when the data is transferred to a third party unless he or she asks for that information. In other words, there is no obligation to even inform the data principal when data is transferred to a third party. I think that is something which needs to be looked at very carefully, because there are three positions here. One is taking mandatory prior consent, which was the earlier 2022 draft, which was too onerous. Now we have a situation where it can be transferred without consent and without informing. But I think in keeping the data principal informed might actually help in protecting such data and avoiding the kind of scenarios that Mr. Taparia outlined. The second thing is, if you look at the exemption to the government, I think there have been significant changes in this draft. The first thing is that it's not a complete blanket exemption to all government agencies. Specific agencies will have to be notified by the government. The second thing is that even when they are notified, it can't just give a blanket exemption to an agency. It has to be for the purposes indicated, which is things like national security, law and order, etc., or for the purposes of the Act, all of which I think are fairly standard provisions. So I think the perhaps notion that under this exemption all government agencies will be completely exempted perhaps may be a bit stretched. However, the question that still remains is that if by negligence or by malintent at some level in the government leakage does happen, then how liability will be fixed and how punishment even to the person responsible, especially in cases where there is malintent, that remains perhaps hanging in the air. On the question of the DPB and its independence, I think one step forward has been that in the earlier draft, I think the DPP, the composition, the qualifications, the tenure, the exact scope of the work, all of that was left, hanging. But now I think there is little clarity on the tenure of the members, on the kind of background that they possess, the kind of persons who can be appointed. It's true that the government appoints all of these, the people on the DPB, but so is the case with the appointment in other regulators. If you take SEBI or the RBI and so on. And I think we all know that they have, a considerable amount of independence. So, and moreover, those decisions are further justiciable. Appeal lies to TDSAT. I'm sure the High Courts and Supreme Court will play their role. So I would not put that as a very major concern at this point, because all of these are subject to the provisions of the Act and law. So that would be my take on these issues.
Sure. We're running out of time. I'll come to Ms. Vedashree for her final comments. Ms. Vedashree, one of the concerns that you had raised one of the new aspects that we're seeing, new creatures as a part of this bill, is the power that now the government has given itself to even block. This is a new provision. It wasn't there in the earlier provisions. Your quick take on that, on what this power could entail going forward.
Yes, I think particularly because they can give this power to block getting a data fiduciary to seize its services and blocking their websites. And it's just on the advice of the Data Protection Board with a hearing. But all of us know what it means, to get a hearing. It's not adequate enough. So I am reasonably worried about that particular provision, because ultimately the way the current Data Protection Board is pretty much an agency of government where it's getting appointed, it's getting funded from the Consolidated Fund of India. I would be a little skeptical of it being really an independent regulator. And on its advice, the central government can go ahead and block any data fiduciary. So I think that needs some safeguards built in, and I do hope, and I'm a little confident that when these rules actually get notified, there are some safeguards built in. Otherwise, it is definitely a worrying prospect for industry, large, big, and small. And one more point which I'm reasonably worried about is the fact that the Data Protection Board, which doesn't seem to be a totally autonomous independent regulator, having the final power, and even nobody can appeal to any court. So it is just the TDSAT. And TDSAT is again an agency of government under TRAI, who are used to dealing with regulated entities like telecom providers, broadband, and other broadcasters. How will they, scale up or rejig themselves to be able to be the appellate tribunal for data protection principles plus fiduciaries is something that we need to watch out.
Right, Ms. Vedashree. On our panel, we have a rich diversity of views on this new creature that's on the block, the Data Protection Bill. It's finally here. We'll, of course, need a lot more clarity on when the rules are drafted. Quite a lot of question marks, but at least there is a degree of welcoming that people have welcomed this new latest creature, this new latest legislation. I'd like to thank all of our panelists for joining us and sharing their insights and perspective. But that, unfortunately, is all the time that we have. It's a wrap on this edition of News Center. More news and updates will continue right here. Keep watching.